Hi, everybody. My name is Carly Hakim Babi, and today I'm going to be talking to you about estate planning when it comes to our special needs adults. I'm going to be giving you some tools that give us that peace of mind I've been talking about every Friday. That peace of mind when we have those essential estate planning tools for our future. But first, I just wanted to talk about what's going on today with Governor Whitmer's new executive order. First, I just wanted to recap on the total number of cases today. As of today, there are in Michigan 35,291 cases total of COVID-19. There have been 2,977 deaths, which is up 164 from yesterday. And we've had 3,237 cases that are reported recovered as of yesterday. And in order for a person to be considered recovered, it's when in 30 days later you still test negative. And the good news is because of these extraordinary measures that we have taken and that most of us are following, Michigan has dropped out of the top 5 in the country. The extension of the stay-at-home order from today, originally from April 30th to May 15th. So Governor Whitmer's new order, what it means in sum. Social distancing measures are still to remain in place. People are now required, rather than encouraged, to wear a face mask or a face covering in enclosed public spaces, such as grocery stores, if it's medically tolerable. If you're an employer and you have one of these essential businesses that are open, you must provide non-medical grade masks to your in-person employees. A couple of things that have loosened. Landscapers, lawn service companies, plant nurseries, bike repair shops can resume operating now, but they are still subject to social distancing rules. Stores selling non-essential supplies can reopen for curbside delivery and pickup. Big box retailers no longer have to close off their garden centers and areas dedicated to selling paint, flooring, and carpet. People with multiple in-state homes can resume traveling between them. Although it's still strongly discouraged, it is now allowed. All other travel is still banned, including travel to vacation rentals. The order continues to prohibit in-person work that is not necessary to sustain or protect life, with those exemptions for various critical jobs. Restaurants are to remain closed to dine-in customers under a separate measure, and bars, movie theaters, gyms, and other sports facilities are still to be closed. So today, our topic is centered around estate planning and special needs adults, and that advanced care planning, the tools that give us that peace of mind. Usually when a young person reaches the age of 18, or which is the legal adult age here in Michigan, they're legally considered an adult. And for many of us, it's an exciting time. It's full of promise. But for those adults with special needs, these adults may still face medical, financial, or educational decisions which could benefit from the advice and assistance of others. And unless proper steps and advanced planning steps are taken, parents, for example, who have routinely participated in IEPs, which is an individualized education plan, discussions or, doctor's visits or insurance negotiations, those people could find themselves excluded. Before I get into the topic fully, here are some terms that you need to know. Advanced care planning. I mean, what is that? It's a process for setting goals and plans with respect to your medical care and treatment. It requires conversations between the individual and his or her family, key health care providers, and anyone else who may be involved in that decision making. It can begin at any point in a person's life, regardless of, his or her current health state. And ideally it's something that's documented in an advanced directive or recorded in your medical record. It's, revised periodically, and it becomes more specific as your health status changes. A lot of the times, people with special needs children, don't think about, well, what's going to happen, when my child turns 18. I'm the one that usually is at the doctor with them. I am the one that, speaks on their behalf. And this is a topic that is concerning for a lot of parents with special needs adult children, in light of COVID-19. I mean, this is something that's very, very touching. Another term is a health care advance directive. And this is a document in which you provide instructions about your health care wishes or appoint someone to make medical treatment decisions for you when you're no longer able to make them yourself. I did speak about that a couple weeks ago. Another term is a durable power of attorney for healthcare, or sometimes people call this a healthcare proxy. And this is a type of advance directive in where you appoint someone else to make all medical treatment decisions for you when you can't make them yourself. There is another document. It's called a physician orders for life-sustaining treatment. Some people call it medical orders for life-sustaining treatment, or provider orders for scope of treatment. And what these are, it's a set of medical orders in standardized format that addresses key critical care decisions consistent with your goals of care and results from a clinical process. It's designed to facilitate shared, informed medical decision-making and communication between healthcare professionals and patients with advanced progressive illness or frailty. Now, one way to provide continued care for our special needs adult children is by securing what is called a guardianship and conservatorship. An adult guardianship is the legal process in which a guardian is appointed by a court to make personal decisions on behalf of the adult child, including decisions about where he or she lives and what medical treatment he or she receives. An adult conservatorship is a legal process in which a conservator is appointed to make decisions about an adult's financial world, including their property in their estate. An adult guardian or conservator are often the same person, but they don't have to be. And one does not have to seek the appointment of both. So if a guardianship and conservatorship is the parents want one, an official opinion from a physician must be presented to the court, stating the reasons why it is necessary. It's important to note that when a child does not have the cognitive ability to direct his or own financial or medical affairs, then that is when a conservatorship or a guardianship is appropriate. However, guardianship and conservatorship are not always the appropriate tools to protect individuals with mental impairments for a couple of reasons. Number one, the cost to be designated by a court as a guardian and conservator can easily exceed several $1,000s in legal fees. Second, a guardian is required to provide significant attention to the incapacitated adult. Number three, the guardian has to report at least annually to the state as, to impart living arrangements, medical, mental, physical, and social condition, and the scope of services provided, and whether those services provide adequate care to that individual. Also, the guardian directs the living arrangements and health care of the incapacitated individual. And a lot of the times, those decisions are very challenging. A full conservatorship, on the other hand, is even more complicated. It requires significantly higher maintenance. A full conservator is required to post surety on a bond with the court. They must annually report on all income received on behalf of the adult child, and annually report all funds expended on behalf of the adult child. This means that conservator must collect and keep records of all receipts, checks, bills, to the penny. And, without help from an accountant or a financial planner or, anything like that, this can be very time consuming and can be costly. And the last thing about, having a guardianship or a conservatorship, you really have to think about whether it's critical that your child needs that, because it could infringe on their independence if it's not tailored to their needs and their level of functioning. So, for example, a child who is autistic, that child may be able to work, earn an income, ride public transportation, drive a car, pay rent, and they may not really need such, strict, stringent control after they turn 18. So to determine whether a guardianship or conservatorship is right for your particular case, the process you have to keep in mind is it starts about 6 months before your child turns 18. And there's a couple of things a couple of factors rather that we need to assess. And it gives us that understanding of whether our adult children can handle independently and under what circumstances they might benefit from additional perspectives and help. These factors include the following. Number one, whether your child is capable of communicating his or her needs and wants regarding his or her care, the degree to which the child can adequately feed themselves, clothe themselves, and otherwise take care of their basic needs. Number 3 is whether the child is employed outside of the home. Number 4, whether the child will require outside care. For example, if they have to live in a assisted living facility or something like that, or a group home. Number 5 is the degree to which the child can understand the effects and consequences of his or her actions. Number 6, the income and finances of your child and your own family. Those are the factors that you have to really consider before deciding whether you have a guardianship or conservatorship or whether something else is appropriate. So what is that something else? It's a power of attorney, and we have to remember that it can only be executed if our child has sufficient mental capacity. That's the key buzzword, is capacity. It's not ability or disability. And in fact, determining capacity is the heart of that decision process. And we don't have a legal checklist that can be used to determine whether your child meets that capacity level. It's a very individualized approach, and that's why those factors are necessary. So if your child has a diagnosed condition affecting that decision-making capacity, it's important first to secure a medical opinion as to your child's individualized mental capacity. And if that decision-making capacity is not a factor, then it's, general practice that an adult child with that sufficient capacity must be able to understand the following. Number 1 is the nature of a power of attorney, the effect of signing a power of attorney, such as when the power begins, and the subject matter over which the agent or the a parent or whoever is assigned can exercise control. Also, that the power of attorney can be limited or broad. Number 4 is that the power of attorney can be revoked so long as the child has the capacity to do so. And lastly, that the power of attorney continues even if the adult child becomes incapacitated. So normally I would meet with the adult child alone without their parents there. And this allows us to really make that really difficult decision that attorneys that draft these powers of attorneys have to make. And it'll help us determine whether the adult child has a sufficient capacity to execute these powers of attorneys, and that the terms in the power of attorney are carefully crafted and directed by the adult child at their own individual case. It's not a blanket provision. It must be carefully crafted and tailored to each individual following an opinion from their doctor. An issue that really I believe needs to be acknowledged by the parents is that if your adult child has a sufficient capacity to execute these powers of attorney in favor of his or her parent, He or she can also execute powers of attorney in favor of another person. For example, I once had a client call me expressing their deep concern that their middle-aged adult child with some mental impairment had recently executed a power of attorney in favor of his girlfriend. And the concern was that the girlfriend may take advantage of my client's son. And the real issue here was that it needed to be considered if the power of attorney sounds like an easy, just cost-effective solution to managing your adult child's care. So even though this power of attorney just seems like a blanket document, it's not. It's complex, and it's especially true when adult special needs children are slightly mentally impaired, and the determination of capacity is a close call. A power of attorney is a far less invasive means of providing the care of a special needs adult child. It requires almost no maintenance, unlike a guardianship or conservatorship, as I explained before. And it's really a low-cost method to ensure the continued care of our special needs adult children by the parents. So as I was explaining before, how these power of attorneys, and when it comes to estate planning and our healthcare, we call it an advance directive. So these are tailored to meet individual specific circumstances. They don't involve the surrendering of any rights, and they can be dissolved at will. And they can also simply facilitate the voluntary addition of others to their individual team of decision makers. Sometimes we don't always just have one person making those decisions for us. Sometimes we have a team. And that, by having that advance directive, it makes that process more easier as time goes on. And these advance directives can also really be an invaluable aid to support those that make those decisions on behalf of our adult children. And it gives those trusted others, if that's the term we can use to call them, to access important records and the right to speak on our individual's behalf. So the last thing I'm going to talk about is that it's very crucial to take your adult child's needs and wants, and if they're capable of expressing them, into account. And you use that information that you gather from your child into determining how to provide that care for him and what's the best thing for them. And, apart from moral sensitivities, Michigan law provides that fiduciaries in charge of our child's care allow our children to participate in this process as much as he or she is able to. I think that's very important, especially because if the child has no input at all in the process, this could really disrupt relationships with their parents and making this process emotionally taxing on everyone involved. So depending on the your precise stipulations on what exactly is necessary or crafts into your individual plan, there are a lot of things that we can do. because everybody is different. So other considerations in closing when deciding to whether pursue a guardianship or a conservative or these executive powers of attorneys for our special needs adult children, it's really important that we have this discussion that includes the consideration of whether our child is receiving or will receive, for example, public benefits, whether the parent has completed his or own estate, because public benefits and the special needs of our children go hand in hand with topics, for example, appointing a representative for Social Security payments or preparing special needs trusts and the relationship of the child to the parent's own financial estate. So in evaluating whether a guardianship or conservatorship or these powers of attorneys are appropriate, we have to consider the adult child's mental capacity, the ability of the child to manage his or own affairs, and the deprivation of rights imposed by a guardianship and conservatorship. So if our adult child with special needs has the capacity to execute powers of attorney, then that's a really good first step. And if a formal guardianship or conservatorship is needed down the line, then that also may be sought at a later time. Just remember, having these advanced planning decisions made beforehand, before we're faced with a situation where we're not prepared to be in, like COVID-19, it's always good to have that plan ahead of time to give you that peace of mind. Thank you for tuning in, and I look forward to coming back next Friday with some more estate planning tips. Have a good day. Bye-bye.